So thanks a lot to the organizers for having me here. I'm honored to have been invited to contribute to this fantastic conference. I have to admit I'm always a little bit nervous to speak. I'm always nervous to speak, but especially on large carnivores, because I can perfectly well imagine that there are many amongst you who initially think, what is a guy from the Netherlands going to tell us about large carnivores? There are no wolves, large carnivores in the Netherlands. But before you ask your money back, I can explain. I am a lawyer. I look at the law applicable to large carnivores, and that can be done from any location, really, so including from the Netherlands. But I now have a second excuse. Wolves are actually beginning to return to the Netherlands. I was absolutely thrilled to see some vague little dots on the last wolf distribution map presented by Petra Kaczynski in the Netherlands. And the first picture taken of a wild wolf in the Netherlands after 1.5 centuries of absence is this picture here in the lower left corner by a shaky mobile phone from a car. And it's wonderful because it perfectly fits the style of Vincent van Gogh. I mean, it couldn't have been more pretty, this first wolf sighting. And quite a few wolf sightings in the Netherlands have happened since, so that was in 2011, and these are in later years, different situations. Some turned up dead, but quite a few alive. So some were run over by cars, but others managed to survive a few days in the Netherlands at least. And some of them stayed out of the picture. The map in the middle is of a colored wolf that was tracked, and people, Ilka's team, really knew that wolf was in the Netherlands because of the signals they received, but the wolf didn't show itself. Other wolves definitely showed themselves. Here's my favorite picture of a wolf in the Netherlands because it has the little windmill, the final proof. And talking about coexistence, it's perfectly adjusting to all the rules. Rules are important in the Netherlands. You can see it is using the sidewalk. And this is very recent. Another wolf turned up a few weeks ago. The image above, it may be a bit difficult to see, is a still from a video. I'll try to see if it works. But it's crossing a road in a village center just a few kilometers from my house, actually. And it's just letting the bicycle pass first before it crosses the road. No, it doesn't play, but you get the idea. And then the still from another video below is the same wolf the next day trying to cross another road, a really busy Dutch highway. And the video clip by another mobile phone from a car shows the wolf trying to cross and almost being squashed by a truck, just veering back off the road. It barely escaped with its life. Later it successfully crossed, actually. So those are the challenges the wolves will face in the Netherlands, obviously. And that sort of brings me finally to the topic I am supposed to talk about, which is zoning, which of course involves questions like, should we let the wolves decide where they want to be, or should we regulate that to some extent for them? Zoning, of course, being applying different rules in different areas. Zoning is one of the many means available for authorities to pursue objectives on wolf conservation and management, including in particular the minimization of conflict with human interests. Various basic sets of actions can be distinguished when you talk about zoning for wolf conservation and management. One is to manipulate wolf density in particular areas, either upwards or downwards, by removing wolves. Secondly, adjusting the way conflicting human activities are conducted. And thirdly, removing such conflicting activities from wolf range. So different ways. And of course, in zoning regimes, There are different combinations, many shades of gray in which such actions can be applied, tailor-made. Very much simplified, you can have zones where wolves receive favorable treatment and other zones where they receive unfavorable treatment. And last of all, there's a sliding scale of management options that can help also contextualize things, ranging from actively preventing the presence of wolves in certain areas to actively promoting their abundance in certain areas. Of course, there's a lot that can be said about zoning, many arguments in favor or against the zoning and the way it should be or should not be applied. I will only look at the role of two international legal instruments mentioned before, the Habitats Directive of the EU and the Berne Convention of the Council of Europe, which set out certain minimum requirements that governments in Europe must take into account when it comes to zoning. And I'll first go through two slides just to try to capture in a nutshell what each regime, each instrument is about. So the Habitats Directive in general terms asks of EU member states to ensure a favorable conservation status for wolves. It tries to achieve its goals through both area protection rules and general species protection rules. Regarding area protection, there's Annex 2, and where that regime applies, member states must designate special areas of conservation for wolves, and then regarding those areas, certain conservation obligations apply. Regarding species protection, when Annex 4 applies, that means the system of strict protection, where the killing and capturing of wolves must in principle be prohibited, and exceptions can only be made under certain strict conditions through derogations. And where Annex 5 applies, a more flexible regime applies, where also the goal of a favorable conservation status must be achieved, but no prohibition of killing individual wolves is required. Now, regarding the application of these regimes to wolves, there are a lot of guidance documents that have been developed by and under the auspices of the European Commission, inter alia with the help of the Large Carnivore Initiative for Europe. And the interpretation of these rules is, in the last instance, up to the EU Court of Justice. And Petra Kaczynski said that with mapping, the devil is in the details, and the same is very much true with law. So interpretation is key. Now, regarding the Berne Convention, roughly similar considerations apply. In general, the countries that are parties to the Berne Convention must assure a certain minimum population level, which is less defined than under the Habitats Directive. And then there are equivalent, roughly equivalent regimes. Appendix 2 means obligations to designate areas and ensure strict protection of wolves. And Appendix 3 means a more flexible regime. Guidance being provided by the Standing Committee that meets every year and where all the parties are represented. And interpretation also being provided by the Standing Committee, and in theory it could be provided by arbitral tribunals established under the Convention. So now, what are these regimes? What is their relevance for zoning? There are two basic dimensions to the relevance of these two instruments to zoning for wolf conservation and management. The first is that these instruments themselves, through the application of the different legal regimes we just let pass in review, provide for a high-level zoning regime, which I will illustrate in a moment. And the second dimension, importantly, is that these instruments determine the legal scope within which national authorities can design and implement more specific zoning regimes for wolves. Now, regarding the first dimension, the default regime for wolves under the Berne Convention is Appendix 2. And those are the dark yellow countries in this picture. But many states, when they became a party to the convention, took advantage of the possibility to file a so-called reservation regarding wolves, meaning that either Appendix 3 applies if they indicate so, or neither of the regimes. So this results in this map of the legal landscape for wolves under the Berne Convention, where different legal regimes apply according to the country where a certain wolf happens to be. So that by itself is a high-level way of zoning, having different regimes apply in different places. Similar story goes for the Habitats Directive, where in most countries wolves are subject to the Annex 2 and the Annex 4 regime, so regarding protected areas, the Natura 2000 network, and strict protection, but in a number of countries, different regimes apply. And if you combine those two, the Berne Convention and the Habitats Directive, you get this complicated legal landscape with many different combinations of regime applying, which is really a way of zoning at the very highest level. And of course, the boundaries between the different regimes in this map are, in most cases, political boundaries, international frontiers, which from a biological and conservation point of view are very artificial and make little sense. And given that most wolf populations are transboundary, there's a great need to coordinate, as has been stressed a few times before, coordinate management and conservation of wolf populations amongst all countries involved in each population, as recommended in the 2008 guidelines that were mentioned before. In some cases, there's this high-level European zoning within a single country, Spain being a particularly interesting example, where wolves are subject to Annex 4, except to the north of the river Duero, the dark river in the picture. And then wolves started to expand their distribution, crossing the river into a different regime, and also some wolves started appearing in Catalonia from the alpine wolf population. And then, of course, the interesting legal question is Catalonia north or south of the Duero, whereas really it is east of the Duero? But this is all food for lawyers, obviously, which people like myself, strangely enough, enjoy, to some extent. Another level at which European regimes provide for zoning for wolf conservation and management is through the protected area regimes. Under the Habitats Directive, the Natura 2000 network of special areas of conservation designated for wolves. In those areas and around them, particular rules for wolf conservation apply and must be taken into account by authorities. And the same is true for the Berne Convention regarding the Emerald network of sites established under the Convention. Now, regarding the second basic dimension of the relevance of these instruments, as said before, these instruments set out minimum requirements, hard legal obligations that national authorities must respect when they design and implement and operationalize national zoning regimes. So, in a way, these international instruments provide the bandwidth, the scope within which national authorities can devise more detailed regimes. Now, a few general things are on this slide that can be said about this dimension of zoning under the Berne Convention and the Habitats Directive. First of all, zoning as such is generally in conformity with the Convention and the Directive. It's not against these instruments to distinguish between different areas in the management of wolves. Also, zones where wolves are treated favorably are generally in conformity with both instruments, especially given that they impose minimum requirements, and states may go further in the level of protection they provide to wolves. Secondly, the level of ambition that these instruments aim for is high, but not that high. In particular, actively promoting thriving wolf populations in all parts of a country's territory is not necessarily required. Some guidance has been provided in this regard by the Standing Committee of the Berne Convention. The committee has adopted a recommendation urging states to welcome the natural expansion of large carnivore populations, especially where this may help a population to reach a satisfactory conservation status and/or improve its genetic variability. And the action plan for wolves that was adopted under the convention in the year 2000 contains the recommendation to allow the wolf to recover and live throughout Europe wherever it is biologically and economically feasible, which is a text that by itself also points in the direction of a high but not incredibly high level of ambition. But the key point from the legal point of view is that the various legal regimes under the Berne Convention and the Habitats Directive impose these minimum requirements that must in any case be respected. Some specific guidance on zoning for wolves has also been provided under the Berne Convention. Almost 30 years ago, a recommendation was adopted recommending parties to identify areas with different potential value to wolf conservation, mainly of three kinds. Zones where the wolf would be fully protected, zones from where selected wolves could be removed according to a management plan, and third, zones where the wolf could be hunted with only the limitations of the current hunting regulations. And this recommendation was directed in particular to parties who had filed a reservation for wolves. So in those countries, legally speaking, there's no appendix that applies to these wolf populations, and that gap, one way of filling that is through this kind of zoning regime. The action plan for wolves also recommends the identification of a zoning system for wolf management. And this is from the action plan, and we'll just go through the first bit. Without prejudice to the aim of conserving viable wolf populations, it would appear that zone management can be contemplated today. So this is within the framework of the Berne Convention. This would involve protecting the wolf totally in only a part of the territory, thereby alleviating the recurrent conflicts with farmers in the more severely hit areas. This would mean applying a number of measures, both preventive and reductive, including local removal of a few individuals. And that leads us to the kind of zone that would also be part of zoning regimes where wolves would receive unfavorable treatment. An extreme form, of course, of such a zone is a no-go zone, an exclusion zone, or an area where a low density for wolves is the express objective. And that's a question that in the final part of this presentation I will deal with in some detail, looking at the extent to which such no-go or low-density areas are compatible with the Habitats Directive and Berne Convention regimes. And in a bit of a simplified form, you can see that in the red regimes, indicated in red, that's where you can expect most legal problems when you design as national authorities, when you design and implement such low-density areas, which are Annex 2 and Annex 4 of the Habitats Directive and Appendix 2 of the Berne Convention. So where those apply, things get tricky from the legal point of view. To illustrate, the Annex 2 regime, where that applies to wolves, EU member states have the obligation to designate the most suitable areas as SACs, so special areas of conservation for wolves. And the case law of the Court of Justice of the EU makes clear that it is really up to the animals in question which the most suitable areas are. So in the case of water birds, for instance, if they show that they prefer to be in a harbor area, which can be pretty inconvenient from a socioeconomic perspective, still that is the area that the member state in question must designate. So considerations of a socioeconomic nature cannot play a role in the choice of where these areas, Natura 2000 sites, will be designated. So for wolves, it means that the choice of terrain, according to this jurisprudence of the court, is up to the wolf. And then obviously, if authorities in advance declare a certain part or parts of the country as an exclusion zone for wolves, that does not sit well at all with this obligation. Furthermore, for areas that have already been designated, Member state authorities are under the obligation to take the necessary conservation measures for the species in question, corresponding to the ecological requirements of the species, also to avoid significant disturbance of the species in those areas, with disturbance being a term that is interpreted very broadly, so really encompassing all kinds of negative influences. And plans or projects that can be harmful to the wolf in designated sites for the species can in principle not take place unless very strict conditions have been complied with. So in conclusion, to designate low-density areas in or around Natura 2000 sites designated for wolves is legally problematic. And the same applies to areas where the regime of strict protection under Annex 4 applies. There, member states have the obligation to establish and enforce the prohibitions to kill or capture wolves. And exceptions can only be allowed through the route of Article 16, namely through derogations. And those can only be decided to use when three conditions are complied with. Cumulative conditions, there must be a reason that fits Article 16.1, A, B, C, D, or E, which include reasons like protecting wild fauna, preventing serious damage to livestock, public safety, the broad clause imperative reasons of overriding public interest, and a number of other purposes. So first of all, there must be one of those purposes that the reason for the zone matches with. Apart from that, there must be no satisfactory alternative. So when satisfactory alternatives for removing wolves exist, those must be used rather than removing wolves. And third, any derogation may not, in principle, be used when this impairs the achievement of a favorable conservation status. Now, these criteria, the court has made this clear again and again, must be interpreted strictly because they are an exception to strict protection, and strict protection is in accordance with the purposes of the directive. The burden of proving that all the conditions are met in each case are for the authorities. And with low-density areas or other zones, of course, member states would have to prove that the conditions are met for the entire duration that the zone is declared for, because it would not be a one-time operation, but if you talk about exclusion zones, you talk about removing wolves whenever they appear. So again, this would be, generally speaking, problematic, would require very creative legal reasoning to argue that low-density areas can be compatible with the Habitats Directive Annex 4 regime. Provide one example before I wrap up. To justify an exclusion zone where any trespassing wolves will be lethally removed, authorities must demonstrate these 5 things: that within a specifically delineated area, because zone is always delimited, a situation arises fitting one of the reasons just mentioned, which can only be addressed by killing all wolves appearing in the area. Fourth, that such removal will not impair the achievement or maintenance of a favorable conservation status. And 5, that nothing of the above will change during the entire period for which the zone is proclaimed. So that can be hard, to put it mildly. For instance, the criterion of proving that satisfactory alternatives to killing wolves are absent are usually, that's a difficult criterion to prove, even in one moment in time. But to prove that that will be the case also 5 years from now, if the zone is designated for 5 years, that will be really hard to do. For those of you who have understandably dozed off, this slide summarizes what I have been trying to say in the past 20 minutes. So, regarding the relevance of the Berne Convention and the Habitats Directive for wolf conservation and management, zoning. First, the Convention and Directive provide themselves for a high level of zoning across Europe. Second, the area protection regimes under these instruments provide for a regime of zoning And third, regarding the scope for domestic national level zoning regimes, domestic level zoning as such is not a problem, legally speaking. Zones where wolves are treated favorably are also not generally a problem. Zones where they are treated unfavorably, well, there it really depends on the details. And no-go or low-density areas, the options for those are really limited and especially problematic when Annex 2 and or 4 from the Habitats Directive apply and or Appendix 2 of the Berne Convention. Thank you for your attention. Molte grazie.